you can take the clients away from the lawyers, but is a lawyer if they don't have any clients? Let's talk about clients. First thing that is important to understand is it's always going to be important to identify the clients. Think about the reasons for that. We need to understand who our customer is, who it is that we're entering into a contract with. And that's important because a large part of the legal relationship between a lawyer and their client is a contractual one. It's set up by the retainer, sometimes referred to as the engagement agreement, but it's essentially a contractual arrangement where in return for the promise to pay money, a lawyer provides particular services, in particular legal services. So we need, and if you remember back to your days of studying contract, in order to have an enforceable contract or to enforce a contract against somebody, we need them to have privity of contract. So think about who your client is and who you have the retainer with. Now, this can come up in a range of different ways. Sometimes, particularly, say, if a lawyer is acting for a child in relation to a matter, they might have the fiduciary obligations to the child, but the contractual arrangements might be with that child's guardian or with the state or whoever it is who is looking after that person. So we can see very easily how the person that we're dealing with might not be the same as our client. And that's something that you should just always be aware of, particularly when you're answering problem questions. Another place where that plays up is when we're working with companies, and there are two scenarios here. One is if your client is a company, then you will be taking instructions from a person within that company who has authority to give those instructions, often a director, but it might be the in-house counsel. The other place where this could play out is if whether we're talking about an exam scenario or in real life, you work for a company as general counsel or as corporate counsel, then your boss and your client are the same legal person. And that can raise particular issues around conflicts of interest. And so the other ways that that can play out or be relevant in the context of our exam in particular could be something to do with the type of practicing certificate that the lawyer needs. So being able to distinguish between your client as your boss and your client as the party with whom you have contract with, but also your client as the one to whom you owe the obligation and the one for whom you must act in their best interest is really, really important. And clearly, probably the last reason for thinking about the identification of the client will always be around ensuring that you don't have a conflict of interest, that in taking on this new client, you can act for them zealously without compromising your obligations to another current client or a previous client. So that's really, really important. The other reason that I wanted to talk about identifying clients or thinking about clients is sometimes we need to or we want to refuse work. And there are a range of reasons why, as lawyers, we might want to refuse instructions that come our way. And sometimes these have to do with a lack of technical competence. So because of the duty of competence, it's not appropriate for us to accept instructions that are outside our area of expertise or experience. But sometimes, in order to continue to be a competent lawyer acting for our other clients, we have to think about what capacity we have and whether we can continue to act in a way that is efficient and is in the best interests of all of the different clients whose needs we're trying to serve, given the constraints on our time, on available technology, on what's happening with current or future work. Some of the questions that you might want to think about here is if you've got a problem that involves competing matters, you might like to think about, well, what questions should you ask in order to identify whether or not the firm should take a client on? So what's the current and future workload like? Do you have a lot of people who are about to go on maternity leave or long service leave or are about to jump ship and go to another law firm? Do you have the available time to undertake the matter and to manage proper communications with the client? Our duties to our clients include being able to communicate properly and to take proper and full instructions. If we are being asked to assist at the 11th hour, is there enough time to competently and diligently understand what the matter is about and provide our client with the range of options in sufficiently clear language to ensure that we get good instructions? When it comes to 11th hour matters as well, another thing to think about is, has there been somebody else acting for the client up to this point? And if there was, why are they swapping lawyers at this point? What has the problem been with the prior lawyer? Now, we're not looking for reasons to bitch and moan about our competitors here. We're really trying to understand, is this a client whose needs can be satisfied? Have they been let down by the other law firm? Or could it be that their expectations are unrealistic and we have to take that into account? Now, it is really important that we take into account whether we have the technical expertise and the resources available to undertake a matter. And we've got to think about the risks that clients pose to our law practice, in particular conflicts of interest, which I've already mentioned. It's also important to try and understand what the client's objectives are enough to work out whether or not we can competently meet those objectives. Sometimes this is about understanding our client's real problem and thinking about what the various moving parts are that could result in us being able to achieve their objectives or perhaps let them down. Now, sometimes there will be just unpopular clients. Some of us will just not want to work for particular clients. There will be, let me use employment lawyers as a really good example. Employment lawyers tend to practice either as employer lawyers or employee lawyers. And if you are an employer lawyer, taking on an employee can mean that you actually have a different kind of strategy in your head, but that can actually have commercial issues with your employer contract. It can lead to more conflicts of interest. It might just be something that you don't want to do. And conversely, taking on matters for employers could impact negatively your employee practice. Then, of course, there'll be just the out-and-out bad guys. On the slides in week 8, which is when we talked about these issues, we looked at a picture of the perpetrator of the massacre in Tasmania many years ago. I'm actually struggling with words here because I don't actually want to say his name for reasons that my understanding is that most perpetrators of heinous crimes like that, the reward that they get is their name being said out loud and being remembered. So I'm not saying his name on purpose and therefore stumbling around my language. But so if we're thinking about the Port Arthur massacre, I doubt anybody was putting up their hands really quickly to act for that person. It's a really good idea to think about that. What does that mean? How are the interests of the administration of justice served when people like that scramble to get lawyers? Now, clearly one of the solutions to that problem is what's called the cab rank rule, which is one of the barristers' conduct rules, Rule 19 from memory. I will put in bold whether that's correct or not correct. the point here is not the rule. You will have access to that in the exam, right? You will be able to find the relevant rule if you're thinking about the cab rank rule. What is really important here is for you to be able to think about why we have a cab rank rule. And probably more importantly, this is a really good example of a rule where you might be asked, is it effective? Does it work? Should there be law reform? Because it's a natural precursor to a question like that, because the rule is slightly different for barristers and for solicitors. So solicitors can say no to any matter, but a barrister effectively can't say no if they have expertise in the field and the particular client is prepared to pay their fees. But in practice, barristers suddenly take holidays, or they might suddenly put up their fees dramatically, or suddenly find that they're very, very busy in an unexpected way. So in practice, does it work? Is it effective? Do we really need it? These are things that I'd just like you to ponder on. And I think with a range of different rules, if you think back to why and then think, does it work? You will be well placed during the exam. Questions, concerns, frustrations, compliments, you know where to find me. Cheers.